Greetings to all. We welcome you in today's session. The theme of today's session is Changing Contours of Public Policy in International Commercial Arbitration. To address the subject of the session, we have with us Mr. Tariq Khan, sir. Sir is a principal associate associated with Advani and Co. Sir has written various articles and has authored the most celebrated book on the rise. His area of expertise in cases arbitration and insolvency law. Recently, Sir has been conferred with the prestigious membership of Business World Legal 40 Under 40 Club of Achievers. We thank you, sir, for sparing time for us from an extremely busy schedule. And now I would like to request you to further proceed with the session. Also, to all who are watching this session, you can just drop your questions in the comment box, and the questions will be asked after the session. You can proceed, sir. Thanks.
Thank you, Animesh. Thank you, Ananya. Thank you, SCC Online. And a very, very good evening to all of you. I would also like to thank the Law Culture for giving me this opportunity. It's a great platform wherein I think ideas are being exchanged, and they provided this opportunity for me to probably share my views on public policy and how the definition of public policy has changed over years. I'd like to start by borrowing the words of Justice Burrow, wherein he said that public policy is an unruly horse. When once you astride on it, you do not know where it is going to take you. So that is true in the sense of the Indian jurisprudence also. The way we have witnessed in the past 20 years, 30 years, especially after the 1996 Act, how initially the courts were construing the term public policy very narrowly. And it's only after the amendment of 2015 that we have seen some development and a pro-arbitration stance is being taken by the Supreme Court repeatedly. Of course, unless the NAFED judgment happened. I will take you through the history of public policy and how the judgment evolved over years. But I think first I'd like to tell you what is public policy and why it is so important. You may have heard of this term a lot of time, especially if you are interested into arbitration. You may have seen from time to time that a lot depends on how the courts are interpreting the term public policy. So let me explain why it is important to construe the term public policy narrowly rather than construing it broadly. You know, it should not be inclusive, it should rather be conclusive. So there are jurisdictions. I'll just give you the international approach first, and then I'll begin with the Indian perspective. So at the end of the day, the idea of providing a robust dispute resolution mechanism is to attract investors who can invest trillions of dollars in your country, which will eventually boost up your economy, help your country become the hub of international arbitration, and will of course generate a lot of employment. Whenever a foreign investor has to invest in a particular country, the first and foremost, the criteria which is of paramount importance is that what is the dispute resolution mechanism in that country? What is the approach of the courts of that country? Because any investor who wants to feel comfortable in an environment where he can smoothly do business, and if he is risking so much of his money, at the end of the day, his money should not get stuck in the court's litigation. And if at all he wins a dispute against a party, the money should come back to him. He should not be deprived of the fruits of the award. So that is the whole purpose of interpreting the term public policy. Because in a lot of cases, what has happened is that investors invested a lot of money in India. Disputes happened. Award came. When they went to execute the award, the Supreme Court said, no, it is against the public policy of India, and therefore we will not enforce this award. Now what happened? The investors were deprived of their money, and they felt that India is not a safe jurisdiction to invest money. And internationally, the message that was delivered by the court was that if you come with a foreign award, there are chances that we will be, not be inclined to enforce it, as we may let the other party take an objection that the award violates the public policy of India. Therefore, investors are investing in those countries where the courts have taken a very narrow approach so far as public policy is concerned. For instance, courts in London, courts in US, they interpret public policy narrowly. They do not let any objection come into the public policy definition. Because if they permit that, then it will open Pandora box. It will open the floodgate of litigation, that every award will be challenged. It will become a thumb rule, and nobody will be able to enforce their arbitral awards. Therefore, they'll be deprived of the fruits of the award. And thus the very purpose of arbitration, which is expeditious resolution of disputes, will get defeated, and it will become another litigation. Now, without going into the philosophy any further, I will just stick to the topic and only tell you what is the approach of the Indian Supreme Court so far as public policy is concerned, and how the Indian courts have transformed the definition, or probably given different views, because there has never been a fixed answer. So I'd like to start by the very first judgment, which is the most controversial, or no, not the controversial, the most popular one, which is Renu Sagar versus General Electrical. You may have heard of this term. All the law students who are studying arbitration, in fact, lawyers, may have heard about the term Renu Sagar quite a lot. So Renu Sagar is the name of the case, which is a landmark case. The citation is 1984 4 SCC 679. I'd like to request Animesh to put it in the chat box so that any person who wants to read the judgment can perhaps go and read it, because these are important judgments. So this judgment, as you know, is an old judgment. And by that time, 1940 Arbitration Award was going on, Arbitration Act. And there was no provision under the 1940 Act to deal with foreign awards. Therefore, there was a different act called Foreign Awards Act, which was for recognition and enforcement of foreign awards. This act was of 1961. The 1961 Act, which was later on repealed, the act, like I said, the Foreign Awards Act, it was repealed and part 2 was added to the 1996 Act. Anyway, that is not relevant today. So under this judgment, what had happened? I think this is one of the first cases, in fact, the first case which I'd like to start from, where public policy was discussed and explained in true sense as to what is public policy. I don't think it is easy for anybody to explain the meaning of public policy, because when we think of it, it differs from jurisdiction to jurisdiction, from person to person. Different people may perceive public policy differently. So I feel that it was very important to narrow down the scope and definition, so that tomorrow nobody can take advantage of the wide expansion and the wide definition of public policy. Therefore, what Supreme Court did? Supreme Court tried to give a message that, look, the idea is to promote trade, and we must narrow down the definition of public policy, so that tomorrow nobody should come and say, no, this award, every award is against the public policy. So I'm going to tell you what is public policy. Now, what Supreme Court did, Supreme Court gave 3 elements of public policy. And Supreme Court said that if these 3 elements are satisfied, then your award, you can challenge an award if it is violating any of these 3. And we will call it against the public policy, and we will not enforce it. Though in this case, the award was ultimately not enforced. But the Supreme Court laid down the law on the point. The first condition which Supreme Court said was the fundamental policy of Indian law. Secondly, the Supreme Court said that if the arbitral award is against the interest of India, interest of country, then it will not be enforced. So this was the second ground. Thirdly, Supreme Court said that if the arbitral award is against morality and justice, then also it will be considered to be against the public policy of India, and thus it will not be enforced. So these were the 3 broad principles which the Supreme Court laid down. And this was a simple case wherein Government of India had refused to restructure the payment plan, and there was a delay of about 3 to 6 years in making payment to General Electric. And General Electric, they invoked the arbitration clause. So what Supreme Court said? Supreme Court said, look, we are not going to enforce the award, but we are laying down three broad principles that if the award is against the fundamental policy of Indian law, or if it is against the interest of India, or if it is against the principles of morality and justice, we are not going to enforce it. But nothing beyond this. No fourth ground is available. This was treated to be a very good law because it said that contravention of law alone will not be sufficient to attract the bar of public policy. That tomorrow you cannot come and say, look, law has been there has been a contravention of a particular law. You will have to bring something more than that to challenge an award in the garb of public policy or to attract the bar of public policy. So this was clarified. So I think it was a very positive judgment considering those times. And I think the message was loud and clear that we are not going to entertain any argument in the name of public policy. We are going to restrict it. Now, until 2003, this was considered to be the good law unless we saw the judgment of ONGC versus Saw Pipes. Now, Saw Pipes name is another name which you all may have heard very frequently, though a lot of you may not have known the facts. But I'll tell you what it was. So ONGC, what it did, it withheld the payments of Saw Pipes. Saw Pipes was to deliver an equipment for offshore oiling. And this equipment was not delivered in time, due to which ONGC said, look, I'm going to impose liquidated damages on you. Now, there was a clause in the agreement which talked about pre-estimate liquidated damages. That in case any delay happens, I'm going to impose X amount of money on you as liquidated damages. Now, when the damages were imposed by ONGC on Saw Pipes invokes the arbitration clause. The arbitral tribunal comes to a finding that since ONGC could not prove any actual loss, because for awarding any liquidated damages, you must show what loss has been caused to you. We will not be granting you any liquidated damages. ONGC said that this is against the substantive law of the country because the Indian law was applicable to the arbitration. And since there was an agreement between the party in relation to pre-estimate loss, the arbitral tribunal ought not to have gone in its own interpretation and should have gone as per the clause. Now, what the Supreme Court said? Supreme Court set aside the award of the arbitrator, saying that the award is contrary to the substantive provisions of the Act. And a very interesting thing happened in this judgment. Supreme Court added one more point, because like you remember, I have discussed Renu Sagar, wherein three elements or three grounds were given for attracting the bar of public policy. This time, Supreme Court added another one called patent illegality. So now patent illegality, in a way, is something which would entail a review on merits, in my view. Because Supreme Court said that if an award is patently illegal, then it will be set aside. So this was the fourth ground which was added to attract the bar of public policy and to set aside any award passed by any arbitral tribunal. Now, in my view, this was also not a very positive judgment. This was, I think, the first judgment which was criticized to a great extent, because it was giving the opportunity to the courts to interfere with arbitral awards, and which is against the scheme of the Act itself. If you look at Section 4, it says that minimum judicial intervention. But this judgment, in fact, gave an opportunity to the Supreme Court to delve into the merits of the case. That's my take on this. Now I'll be discussing another case which is, I think, even worse it was a very dangerous precedent, I must say, in relation to if you want to see India as a hub of arbitration. So this was a very dangerous precedent. This was the case of ONGC versus Western Geco. You may, Animesh, share the citation with them. So in this case, what had happened, there was a contract for supply of hydrophones. And there was some delay on part of Western Geco in supplying the same to ONGC. And as usual, in the previous case also, ONGC was the party. ONGC again imposed liquidated damages and said the delay was attributable to Western Geco. And therefore, Western Geco said that, look, you have exaggerated the penalty, the liquidated damages, and the delay. So much delay is not attributable to me. Now the matter went into arbitration. The arbitrator said in his final award that the delay on part of Western Geco, he reduced it, but he made it 4 months and 22 days, 26 days. I think 22 days, yeah. 4 months and 22 days. Now this decision was again challenged by Western Geco in Supreme Court. And the issue was whether public policy would permit the Supreme Court to go into the merits of the case. Now Supreme Court went ahead a step further. Supreme Court said, look, the decisions which were given earlier, including Saw Pipes and Renu Sagar, they did not explain the term, they did not elaborate on the term fundamental policy of Indian law. So we are going to explain it to you. What is the fundamental policy of Indian law? And they gave 3 broad elements that what would constitute. So if you remember, Renu Sagar explained public policy in 3 parts. Saw Pipes added the 4th one, patent illegality. Now, Western Geco judgment, Supreme Court explains fundamental policy of Indian law into 3 subcategories. The first one was that judiciary should not rule on whimsical basis. That judiciary should not act on whims and fancies. The second one was that decisions given by the courts should be based on principles of natural justice. That principles of natural justice must be followed while delivering any judgment by any tribunal or by any courts. And the third one was that Wednesbury principles of reasonableness must be complied with. Now, what are Wednesbury principles of reasonableness? Basically, that any decision passed by the courts should not be perverse or irrational. So as to, so that an ordinary person should not feel that this is perverse or irrational. That was the idea. So this judgment further increased the scope of interference of the courts, expanded the definition of public policy by giving 3 more subcategories of fundamental policy of Indian law. Now anybody could come and challenge an award showing any of these 3 subcategories. So in my view, that Supreme Court, by virtue of the judgment of Western Geco, gave wide powers to the court to interfere with these awards. And if you look at the harm which was done by the previous judgment of Saw Pipes, this judgment further went one step further, wherein the courts could interfere with every merits of the cases, which is ordinarily not permissible. Ultimately, what happened is the court went into the merits. And if you remember, I told you arbitral tribunal said 4 months and 22 days was the delay attributable to Western Geco. The Supreme Court went into the merits of the case, modified the award, and said that 56 days is the delay, reduced the number of delays, and said that 56 days delay is attributable to Western Geco. So this was an interesting case wherein Supreme Court went into the merits of the case. Another judgment I would like to highlight is the Venture Global versus Satyam Computer Services. This is 2008 1 scale 214. Animesh, you can keep writing the citation of all these cases. In this case also, the Supreme Court did not enforce the arbitral award. And what had happened in this, the Supreme Court observed that what Satyam was trying to do, Satyam was trying to enforce the award in Michigan and trying to evade the extended definition of public policy, including patent illegality, which I discussed with you, came into saw pipes. Court held that as long as parties do not explicitly or impliedly do not exclude operation of part 1, and then which is section 34 is what they were referring to, because it comes in part 1. So they said that the court, Justice Satasivam was there at that time. He said that if you are not specifically excluding by express or implied means, if you're not excluding part 1, then part 1 will be applied to foreign awards also, and even if you are enforcing in a foreign country. So section 34 will be entertained in such matters. That's what he said. So even if an award is not enforced in India under section 48, it can still be challenged under section 34. This was the ratio which was laid down. Another judgment which was, I think, criticized quite a lot at that time. Now, one more judgment wherein public policy was considered as Phulchand exports, not that important. Phulchand and Lal Mahal, I don't think are very important, but I'll just briefly tell you what it is. The citation is Phulchand exports 2011, 10 SCC 300. So the court said that the test which was laid down in saw pipes must be followed even in the case of foreign awards. So they were basically saying that patent illegality which was introduced in the case of saw pipes, the 4th category, this ground of patent illegality will be available even in cases where the courts are dealing with foreign awards. I don't know why Renu Sagar was not applied, because Renu Sagar was a judgment which in a way dealt with foreign awards, though not under 48, because at that time the act was the Foreign Awards Enforcement and Recognition Act of 1961. But in a way it was similar. Whereas the reliance in the Phulchand judgment is on saw pipes, which was dealing with a domestic award. So that is an anomaly which I think should have been considered. But anyway, other judgment is the Sri Lal Mahal judgment versus Progetto 2014 2 SCC 433. In this case, the award was enforced. Again, the Supreme Court expanded the meaning of the term public policy, which was another judgment which I think should not have taken this approach, in my view. The court went ahead and said that section 34 and section 48, the purpose and scheme is the same. So that is the kind of interpretation which was given in a way, because if you know 34 is only dealing with part 1, which talks about domestic arbitrations, and 48 talks about the foreign awards. So what Supreme Court said in this judgment of Sri Lal Mahal, that both in a way have the same scope, and the policy behind the same, the purpose behind the same, behind these sections is same. Another judgment is Associate Builders versus DDA, which is a 2014 judgment, if I'm not wrong, wherein saw pipes and Western Gecko was relied upon. And it said that principles laid down in these judgments were, so basically it was followed. Now, this is the scenario before the Arbitration Amendment Act of 2015. Now, I have told you that these judgments came till 2014. This was the situation. Now, the situation improved when the amendments were to be introduced. Now, I will straight away come to the 246th Law Commission report. Now, the 246th Law Commission report, it criticized both these judgments, ONGC versus Western Gecko and Associate Builders versus DDA, because it said that these judgments opened a floodgate of litigation. And this is the reason why a lot of foreign investment is not coming, why people are not happy, the way the approach which has been adopted by the Indian courts. Now, certain changes were made suggested by the Law Commission, that we must make certain changes. We must bring in an amendment which will change the nature of 34 and we will try to explain the definition. Now I will look at the section and I will read out because I just have the Bare Act with me. So if you look at the language of section 34, what they have done is they have added an explanation which says, I will read it for you. For the avoidance of any doubt, it is clarified that an award is in conflict with the public policy of India only if, now they are trying to clarify, trying to rectify the, the harm, the damage which was done by exactly telling what is public policy. So they're saying public policy of India only if. Now the first is the making of the award was induced or affected by the fraud or corruption. So what they're trying to say is that if the award was obtained or the award was made under fraud or corrupt practices, then in that case it will be against public policy of India. So this is very much clear. That is the first ground on which now, as on date, you can challenge an award. The second situation they have explained is if it is in contravention with the fundamental policy of Indian law. So another aspect which they have covered under public policy is that it has to be in violation with fundamental policy of Indian law. I will come to the judgments which have explained fundamental policy of Indian law after the 2015 amendment. Because the one which was done earlier by Western Gecko was very harmful. The third one is that if it is in conflict with most basic notions of morality or justice. Now, explanation 2 is very important. They said that in 34, you will find it in the amendment of 2015, the new definition of 34, the new explanations which have been added to 34 after the amendment. It says that for the avoidance of any doubt, the test as to whether there is a contravention with the fundamental policy of Indian law shall not entail a review on the merits of the dispute. Now they have again clarified that, look, if you are trying to challenge an award on fundamental policy of Indian law, the review on merits will not be permissible to you. You cannot argue the case again on merits. The court cannot even look into the merits of the case. So the scope of 34 was narrowed down to that extent. So it was a very positive step. And that's why the definition, the 34 language was amended, and these two explanations were added. Now, another interesting part is that 2A was added, which I will just read for you. An arbitral award arising out of arbitrations other than international commercial arbitrations may also be set aside by the court if the court finds that the award is vitiated by patent illegality appearing on face of the award, provided that an award shall not be set aside merely on the ground of an erroneous application of the law or by reappreciation of evidence. Now, I'll explain what is the rationale of bringing these explanations in 2A. So if you remember, I had told you that ONGC saw pipes added a fourth category, which was patent illegality. And the same was followed in Phulchand and other judgments, which said that 34 and 48 are same in a way. And if you remember the Satyam judgment, which I pointed, in that judgment, the court said, Justice Sathasivam said, that even if you are not enforcing under 48, 34 can still be attracted in foreign arbitrations, foreign awards. So this amendment has explained that patent illegality is not a ground for challenge so far as international commercial arbitrations are concerned. So patent illegality, as held in ONGC saw pipes, will now only be a ground in domestic awards. So if you are challenging a domestic awards, yes, you can challenge it under the ground patent illegality. But the same ground of patent illegality is not available to a party challenging a foreign award. So that is the distinction. The second thing, if you have to carefully see, is the judgment I was referring to about Western Gecko. In that, they explain fundamental policy of Indian law, thereby giving an opportunity to the courts to review on merits. And that's what happened in that case. The court modified the award, reduced the number of delays. So now court clarified, look, fundamental policy of Indian law will not entail a review on merits. So court, the language of the section is clear. The legislature clarified that now these two issues were rectified. The ONGC Sopikes judgment and the judgment of Western Gateway. Another interesting aspect is the court said that award shall not be set aside merely because there is an erroneous application of the law or there is an erroneous reappreciation of evidence. So what the court said, if you remember Renu Sagar initially, the first judgment which I referred to, talked a little bit about it, that contravention of law alone is not enough. You need to bring something more than that to attract the bar of public policy. So that is what the amendment has clarified. The amendment said that even if there are some erroneous application of law by the arbitrator, it would still not be a ground to set aside the award passed by the arbitrator. And there is no reappreciation of evidence available to the court. Court cannot go into the merits, therefore restricting and narrowing down the scope of interference under Section 34. So this was a very, very positive step. Excellent amendment. And then we were only to wait to see how it was going to be implemented. Now, after this amendment, I'll just take you because I know we are running against the clock. We don't have much time. So I will straight away come to 2-3 important judgments. One is the MMTC judgment, MMTC Limited versus Vedanta Limited. This is civil appeal number 1862 of 2014. In this case, the Supreme Court enforced the award, and I will read the relevant excerpt. So the court said that as far as Section 34 of the Act is concerned, the position is that the court does not sit in an appeal over the arbitral award and may interfere on merits only on the limited grounds provided under 34(2)(b). That is, if the award is against the public policy of India. Further, an arbitral award may not be interfered with if the view taken by the arbitrator is a plausible view. However, position changed after 2015 amendment, wherein explanation 1 was inserted and scope of contravention of public policy was modified to the extent that it now means fraud or corruption in making of the award. Additionally, in domestic arbitrations, violation of Indian public policy also includes patent illegality appearing on face of the award. Interference under Section 37 cannot travel beyond the restrictions laid down under 34. And while interpreting the terms of a contract, conduct of parties and correspondence exchange between them would also be relevant factors, and it is within the arbitrator's jurisdiction to consider the same. So what happened in MMTC versus Vedanta? The court clarified that, look, now after the amendment of 2015, the scope is extremely narrow and we will not entertain a review on merits. We are not sitting as a court of appeal that we will let you argue on merits. We are only sitting as a court of review, and therefore you will not be permitted to go too much into the details of the case, too much into the facts, or to reappreciate the evidence. Also, the court clarified that the scope of an appeal under 37, which is an appeal against 34 judgment, will be restricted to the grounds raised under 34. So in a way, the court tried to narrow down the scope of 37 appeal also, that you cannot travel beyond what you have argued in 34. Another interesting judgment, it's my one of the best judgments, which I think, SsangYong Engineering and Construction Company Limited versus NHAI. Though the award was not enforced in this, but I think it was a very positive judgment. It's civil appeal number 4779 of 2019. This is by Justice Nariman, a very positive judgment. The court noted that interpretation of the term public policy of India had been narrowed down by the Arbitration and Conciliation Act 2015 and found that amendments to Section 34 of the Act, especially the doing away of the wide interpretation of the term public policy, were substantive in nature. The court affirmed the findings in the case of BCCI versus Kochi Cricket wherein it was held that the amendment of 2015 will not be retrospective except 36(2). And the court said that review on merits is not permissible, because if that is allowed, then it will be against the very ethos of arbitration, which is not permissible. That is a review on merits. So the court criticized and said, we are not sitting in as a court of appeal. We are sitting as if we are doing a review, and you cannot go into the merits. So both these judgments, MMTC versus Vedanta, as well as Sangyong versus NHAI, these are two judgments which I think were very positive and narrowed down the scope further. Another judgment which I think I'm missing is the judgment in Associate Builders versus DDA. In this judgment, when there was a discussion as to what is, if you remember, public policy was defined in 3 terms. The third one was if it is against the notions of morality and justice. So it was explained in this case that award which would shock the conscience of the court will be treated as something which is against the morality or justice, the basic notions, something which shocks the conscience of the court. Another interesting aspect is that morality as such, if I ask you what is morality, a lot of people will have different meaning of morality. Different countries may feel morality in a different sense. Something what may be immoral in India may be moral in another country. So that is one ground which is there, which has not been interpreted in a lot of judgments. I have not seen, at least. But I can give you an example as per my knowledge. For instance, in England, immoral would be an act of solicitation of, prostitution is immoral. So such acts are considered to be immoral, and therefore any award which deals with any such activities which are immoral. There is in fact an act in India, Prevention of Immoral Activities, Trafficking Act. Maybe those categories would be the ones which would refer to as immoral. Gambling, for instance, in a lot of countries has been considered immoral. So there were cases in foreign countries where, they were, the subject matter of the award was gambling, and many countries did enforce it and many countries did not enforce it on the ground, saying that gambling is moral, immoral. Anyway, that's an interesting discussion. You can look at it. Now, moving forward, there's another judgment which I would like to highlight. And this judgment is the judgment in National Agriculture Cooperative Market Federation of India versus Alimenta. This is one judgment which was criticized recently. It's a very recent judgment, Civil Appeal number 667 of 2012. So in this case, the Supreme Court refused to enforce the award. And I'll tell you the operative part. The court said the award is ex facie illegal and in contravention of fundamental law. No export without permission of the government was permissible, and without the consent of the government quota could not have been forwarded to the next season. The export without permission would have violated the law. Thus, enforcement of such an award would be violative of the public policy of India. So this was another judgment wherein the Supreme Court very recently did not enforce an award. And I'm of the view, whenever such a judgment is passed, wherein an award is not enforced, a very negative message goes in the international community. There's another judgment of 11th May 2020, which is Southeast Asia Marine Engineering and Constructions Limited versus Oil India Limited. This is a judgment dated 11/5/2020 in Civil Appeal 673 of 2012. Supreme Court held that interpretation of clause 23 of the contract by the arbitral tribunal to provide a wide interpretation cannot be accepted as a thumb interpretation, and the document forming a written contract should be read as a whole and as far as possible as mutually explanatory. Since the evidence of record does not suggest that the parties had agreed to a broad interpretation to the clause in question, the interpretation of the clause as suggested by the arbitral tribunal was said to be perverse in this case. So what I'm trying to explain to you is that the recent approach of the Supreme Court, if I look at the latest judgment, which is the Government of India versus Vedanta, It is a judgment dated, I think 2 weeks ago, this judgment has come. I will tell you, the citation is important. Please note it down. It is SCC Online 2020, Supreme Court 749. So this is a very important and a positive judgment wherein the issue was that Malaysian courts were applying the public policy of their laws in the challenge of Government of India. So the Supreme Court said that Malaysian courts, being the seat court, were justified in applying the Malaysian Act to the public policy challenge or objection which was raised by the Government of India, and the award was enforced. So I think this is a very positive step, and this was a very good judgment, which is, I think, very recent. 2 weeks ago only it has been passed. So overall, if I like to sum up, because I know I haven't taken any questions, and I'm sure most of the questions must have been answered. But in my view, I'd just like to conclude now, because I've covered almost every judgment which has come up so far, insofar as public policy is concerned, that courts must respect the foreign awards. They must enforce it as a thumb rule, and it should only be in the exceptional cases that foreign awards are interfered with. I am of the view that there are certain examples, certain cases wherein people may have felt that yes, this award should not have been enforced. So unless there is something which is extremely wrong with the award, the arbitral awards must not be interfered with, especially the foreign awards. And India as a country need an industrial revolution. We need more, because largely we are dependent on agriculture as in our economy. But apart from the agriculture sector, I think we need more investment in exports. We need more investment in infrastructure. And I think all of that will happen only if we give a very positive message to the international community that yes, India is going to adopt pro-enforcement bias approach as enshrined in Article 5 of the New York Convention. And we are giving a message that yes, India wants to enforce the awards, feel secure, feel safe, invest your money, and it is not going to be interfered with, and you will not be deprived of the fruits of the award. I think that is the kind of message which we need to give, and we must continue this practice, because any one judgment wherein we give a negative message will overshadow good things that we are doing. So consistency is very important. And the Nefed Alimenta judgment, which I referred to just now, another recent judgment of May 2020, I think was not a positive step, of course, because the award was not enforced, saying that it was not against the law of the country. So this is the long and short of public policy, and I think I've been able to cover it. And thank you for a very patient hearing. Unless you have any question, Animesh or Ananya, I think we can conclude the session. Yeah.
Thank you so much, sir, for such an insightful session. We have a couple of questions that people want to ask. We'll start with the question session. The first question is that do you think these precedents make India not a favorable place for arbitration?
Yeah, so like I said, if you look at judgments like SAW Pipes and Western Gecko, of course, this would reflect that India is not a country which promotes arbitration or which takes a stance pro-arbitration. But however, the recent approach, if you look at judgments like SsangYong, MMTC Limited versus Vedanta, and the recent one, the very recent one in Union of India versus Vedanta, I think in these judgments are reflecting that the position has changed after the 2015 amendment.
Another question is, how do you think the situation would have changed if there would have been wider scope of public policy given rather than a narrow scope?
So if the public policy would have been interpreted broadly, then arbitration would have become second litigation. Arbitration would have just vanished. Nobody would have preferred arbitration clauses. Investors would not have invested in India. And there would have been, even if they would have invested, there would have been no arbitration clauses, because they would have known that if we go for arbitration, our arbitral awards are never going to be enforced, because Indian courts will interfere because public policy is interpreted too widely.
This question is regarding public policy, which basically says that there is a tendency in jurisdiction to weigh public policy differently in the domestic realm and in the international realm. And in Indian jurisdiction, we have section 34 and 48 using public policy. But do you think that public policy has been interpreted differently, or is it the same for both?
So I think the question is, so firstly, answering the first part, yes, it differs from like region to region. What, like I said, that morality, for instance, may be something which is immoral in India, may be moral in another country. So public policy differs from country to country, definitely. So an award which may be enforced in UK may not be enforced in India. But so far as the other part is concerned, after the amendment, I think it has been clarified that the defense of patent illegality is not available in international commercial arbitration. So if you're challenging a foreign award, and there are objections of 48, if you're enforcing an award, I don't think any party can resist that enforcement under on the ground patent illegality. So that's, I think, the key difference, which is available in 34.
All right, so and the last question would be, what in summary do you think should be an approach in determining what public policy is?
So my definition of public policy.
What do you
Is
think
that
the
the question?
should be while determining this public policy? Because answering this question would be important to determine another issue as to what is arbitrable or not in the light of government push for ADR. This is the question.
Okay. So I think, so what the question I think is that if because the government is trying to become the hub of arbitration, so how should we define public policy to make that happen?
Yes.
So I think you can treat it as narrow as possible. You can restrict the definition of public policy, to corruption, fraud, the way it has been done in section 34 after the 2015 amendment. What they have said is something which is an award which is based on fraud or corruption. So yes, fraud is not arbitrable also, and fraud is something which cannot be accepted. Anything which is pyramided on fraud has to go. So whether there's a foreign award or a domestic award, that is something we cannot let happen because we want to be a hub of arbitration. The second thing is morality and justice. Yes, I think it's important, but we need to restrict the scope. Keep it in our mind that the rule is execution and enforcement of foreign awards, and denying the enforcement is just an exception, rarest of rare cases, just like we do in death penalty. So I think that kind of mindset is very important for the courts which are enforcing the awards. And as far as we restrict ourselves and we do not go into the merits, that's the most important part, because in a lot of cases, what I have seen is courts do not shy away from entering the merits of the case. They just get into the merits, they go into the evidence. What they don't realize is the law is clear. But I think a lot of depends on, it's a duty of the officer of the court, that is the lawyer, to ensure that he doesn't take the court into the merits, do not insist on reading the evidence. So all of that should be avoided. All of us stakeholders have a role to play in making India a hub of arbitration.
All right, sir. Thank you for such an insightful session and answering all the questions.
Animesh, thank you. And if you have any last few words for me, I think we'll finish in time.
Yes, sir. Thanks a lot. Yes, sir. So first of all, thanks for sparing time from an extremely busy schedule. And so we would like to thank our media partner SCC Online for collaborating with us for this such an insightful session. And thanks to all the participants who registered for this session and who joined this session. And thanks a lot, sir, for being with us.
Thank you so much, sir.
Thank you, Animesh, for all your research. It was very, very helpful. Yes. And thank you, SCC Online, for giving me this opportunity. I'm extremely grateful to all of you for taking out the time, and hope we'll continue this trend in the law culture. Thank you, everyone.
Thank you, sir.
Thank you.